Okay, in the first part of our discussion of libel, we kind of defined it. We defined it as a tort, a cause of action, a legal procedure that's designed to allow people whose reputation has been injured with false information to recover damages. And that's about as straightforward and simply as we can put it. But that's what libel is all about, protecting people's reputation. And if somebody's reputation is harmed by false information, then they may recover damages. That's in the simplest form. Today, and in this segment, what we talk about is the elements that must be shown to find that libel has occurred. We talked earlier about the fact that in law, each tort or each crime or whatever it is has what's called a cause of action, and the cause of action has individual elements. And in the case of libel, and in other cases as well, each and every one of them must be shown, must be proved in order to recover. If any one of them is not present, then the tort is not complete. If every one of them is present, then the tort is complete, and that's about the as basic as you can get. The elements of libel are published, false statement of fact to an identifiable person, and the publication must be defamatory. It must be believable and result in the actual result in damage to reputation, and that the defendant is legally blameworthy. And we'll go through those one at a time. We think we know what each one of them means because they're pretty self-apparent, but they're little rivulets off the side of every one, as we shall see, especially in an era of digital communications. Things have changed a little bit. The first element is published, and published means spoken or written or placed where others may see or hear it. It can be a newspaper, a magazine, a photograph. It can be verbal. It can be in a broadcast. It can be in a tweet. It can be painted on the side of a water tower. It means some communication that has been made in a position or by a means that other people can see it or hear it. It doesn't have to be a set number of people. It doesn't have to be 50 people, 200 people, 7 people. It has to be more than the person who's complaining about the information. And that's a point where people get tripped up, and we'll talk about that more in just a second. But for right now, know what publish means. It means to put something somewhere where other people other than the plaintiff, can see it or hear it. If one person texts another, I saw you cheating on the test. Is that published? No. It was sent through the internet. It was sent from one smartphone to another, but only the person who's accused of bad behavior sees it. So that's not libel. Libel means it has to be put that where other people can see it. The other example, if somebody sends out a tweet that Bob has leprosy, and the person who makes the tweet has followers other than Bob, 10 followers, 200 followers, it doesn't matter. And if Bob doesn't have leprosy, then Bob's reputation has been damaged, or at least that. But right now we're just dealing with the element of published. And know that, that's one of the things you can be tested on, is something that's just communicated to a plaintiff. Does that constitute publishing? And the answer is no. Publishing means it has to be put where other people can see it, because it's only if other people see it that the interest that's protected, reputation, is damaged. If I say something mean about you to you, that doesn't injure your reputation. It's only if I say something to other people that causes them to think less of you, then that's where reputation injury comes. Now, We can stop there and everybody be happy, but the fact is that there's more to the element of publishing. There's something called a republisher, and the law tends to side with our mothers. You remember your mother would tell you that if you repeated gossip or if you repeated a lie, it's just as bad as if you were the first person to tell it. And the law works along pretty much that same lines. A republisher is a party or an entity that had a choice about whether to reconvey or relate information that they got from somebody else. And if they do so and had a choice about it, then they're as responsible as the person who originated it. Now, moms and their adages are one thing, but as we can see, the law is something that has a lot more serious consequences. If there's a choice about repeating something, the person who repeats it can be as answerable as the person who originated it. On the other hand, there are those for whom the law provides a protection, and that is if the information is merely distributed. Some of this is common sense, but we have to break it down into its little legal neat compartments. If somebody sent somebody else a letter that contained defamatory information about Bob, and the person to whom the letter was addressed opened it and read it and thought less of Bob, Bob wouldn't consider suing, or he wouldn't consider that the postal service, the person who delivered the letter, had caused the injury. The person who caused the injury was the person who originated the letter. All the postal service did, without choice, was deliver the letter to the person to whom it was addressed. The postal service is not responsible for the contents of the mail. This makes perfectly good sense. And if you like the word vendor, think about a vending machine. If you go to a vending machine and you put in money or swipe your card and you get a defective product out, there's some foreign material in your soda or your water, you don't blame the vending machine. You blame the manufacturer, the person who originated it. All the vending machine does is distribute it, and so they're not responsible. For instance, again, another example is a bookstore. If you go to a bookstore, you pick up a book, you see that it contains content that is falsely injurious to somebody else's reputation or your reputation, you don't blame the bookstore, you blame the author and the publisher. Okay, so we see that there are two different things to ways to characterize this. Number one is the person that's the publisher, the person who originated it. Okay, if you're not the person that originated it, then it's possible that you are a person who republished it, meaning that you had a choice and you chose to distribute it. And that the opposite of a republisher is a vendor. It's a person whose responsibility was merely to distribute it. So, as I think I have failed to mention today in these presentations, is libel law is common law. It developed there's no statute on the books about common law, and it's not private law, it's not contractual law, so it's common law. It's developed through situations that have arisen through the decades. And so the rule book is under constant tweaking and constant verifications, and part of that is keeping up with technology. There is positive law in this area, and it's one of the things is that you will run into is called the Communications Decency Act, which was passed about 22 years ago by Congress and is a federal black letter law. And what it does is put in federal law the common law rule about vendors and publishers as it relates to interactive computer services, or ISPs, or in some cases, platforms. The specific language of the CDA is that no provider of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. Why do you think you have those rules? Because somebody found something libelous on Facebook or American Online or something like that, and they said, well, look, you're responsible for the content of your website. And their response was, we're like the postal service. We just deliver the mail. We don't screen the content. We don't manage the content. We have nothing to do with the content. We don't censor the content. So we're not republishers who are responsible as they would be under common law, because we really don't have a choice. We put it out there, and what people put on the platform is up to them. And that's for platforms or interactive computer services that don't have content controls. And we'll talk a lot about content controls, because pretty much when you are employed in an internship or otherwise, your employer will not know these rules and will look to you and expects you to kind of understand, are we in trouble for having this on our website? And there's some pretty good advice that you can pass along to them about items and information that other people put on their website. So by federal law, internet service providers are always going to be vendors. The Congress got ahead of the common law. This makes sense. It says Gmail, Google is not responsible for the content of an email. In the same way that the U.S. Postal Service is not responsible for the content of a letter. So ISPs are out of the realm of responsibility for libelous content. So again, as you look to, originally, you know, somebody's a publisher, that person is responsible. That person created the content, that person put the content out there, that person is the publisher. That's the prime source. After that, when the information is relayed or repeated, the general rules are to look to the issue of control. Liability follows control. If there's control of the content, then the liability, if there was a choice to publish it, then there's going to be a liability that flows with the choice that was made. The text lists out the Communication Decency 206 details for you. I'm not going to read these all to you, but as you read them, you will find, if you want to pause and read them, that pretty much they're describing internet service provider situations where content is solicited, content is not so much changed in terms of its meaning, and basically the ISP is serving the same role as the U.S. Postal Service is. They are just electronically or digitally or in cyberspace providing a stage, and what people do on the stage is pretty much outside their control or liability. Now, there's some closer areas here, because if you recall, when you got your Instagram or your Snapchat, or when you signed up for Facebook way back when, you agreed to terms, number one. We'll talk about that in another chapter. And you know that there's certain content that they don't allow and other content that they do allow. And so you know they kind of screen that actively and passively. And Facebook in the last election especially was accused of giving priority to messages or putting messages higher in people's news feeds that agreed with Facebook's philosophy of government, and either eliminating or making less prominent posts that disagreed with Facebook's employees' viewpoints. To the extent that that's true, it argues for Facebook being responsible as a publisher and not immune as just a stage or just as a vendor. But this is evolving. There's litigation at many levels about Facebook and other platforms and their responsibility for the content. This extends to terror attacks. You know, if there's a platform out there, it's going to be used by the Bridge Club to decide when they're going to meet and play cards, and it's going to be used by ISIS to decide who to blow up. And Facebook has been sued on the belief that they should, as a member-based service, they should do more or should have done more to screen out use of their platform for evil, for bad things, for planning crimes, for planning abuse of peace and quiet. Because you know, you can look on Facebook and see fights, you can see people being picked on and this, that, and the other. And so this is, the society is coming to grips with that. But the cardinal rules are, the clear rules are that if it, under the Communications Decency Act, if it's merely a platform and it's just like works just like the U.S. Postal Service, as far as not carrying what's inside the envelope, just delivering the envelope to the person it's addressed to, the Communications Decency Act says that the ISP is not going to be held responsible for the content. These are very fact-sensitive cases. Courts differ, and very small factors in the facts that led to litigation can make a difference. This is really unsettled and not fully fleshed out, and won't be for many years in terms of what's the liability of Instagram, what's the liability of platforms that require you to be a member and abide by their terms. Okay, Gmail, obviously, you know, a Gmail email accounts, they have no policing function as terms of content, but Facebook does, and Instagram does, and Snapchat does, and others have different ways of managing content. And so you go all the way back to the common law and you say, well, if you're managing the content, then you are responsible because you're making a choice as to whether to include it or delete it. Again, some very simple, some very straightforward examples. Suppose Cindy has a blog and she welcomes a new high school basketball coach. She's the PTA chairman or whatever. She created that content. She's the publisher. Her blog just welcomes the coach, but the site allows content. Now allows comments. We know she's responsible for anything she posts. She would be the publisher. But suppose she has comments, she doesn't screen the comments, and someone posts that the new basketball coach was fired from his job for being a bank robber. Well, is Cindy responsible for that? Under the Communications Decency Act, because she had no control, because she just allowed people to comment, she's a vendor. And she's not responsible for the fact that somebody posted that on her site. And further, the CDA says, now of course, this is this ethics and moral kind of thing versus the law. The law says she's not responsible for taking it down. She would, because Cindy is a decent person. But if she found out it was not true, she would remove it. But the law says that she's not responsible for anything that she didn't put on the site. Again, we could agree that it would be ethical for her to remove it, but obviously the law says she's not responsible for it being there, so it doesn't create an obligation for her to remove it. Now, if you change the facts a little bit and you suppose that Cindy does screen comments, and it's the same factual situation, and she sees the robber comment come in and she just puts it on her site anyway. Well, when she does that, she exercised control over it, and that made her, pretty much made her a republisher. She didn't originate it, but she could own it if she made a decision to use it, okay? Really, students get asked about this on internships. You know, what on my website is going to cause a problem? Generally, there's no problem with screening comments, you know, TripAdvisor, whatever, you know, so-and-so's hotel, so-and-so's restaurant. It's perfectly allowable to screen comments. You're not violating anybody's freedom of expression rights because you own the platform, and so you can control what's posted on it, and you can choose to do that if you want to do that. But the risk you run if you do screen comments is that you will be called a republisher, and if some of the content turns out to be libelous, then you're going to be held to be just as responsible as if you had created it. Obviously, you see, we're all on websites on the internet all the day, and we know that what most people do today, it's the wise thing to do, is to avoid becoming the owner of the content of a questionable item. And so that way you don't screen things coming in, but you just add a report abuse or some button like that, which is, according to the CDA, is content neutral. You don't screen, but you allow viewers to bring to your attention things that perhaps should be removed. That way you kind of distance yourself from it and you're not part of it. Using the report abuse button can also limit liability for copyright, which we talk about in a later chapter. But remember as well that if it's your site, you own it, and you can control without infringing on anybody else's rights. Nobody has a right to post on your property, and your website is your property. So occasionally there are times when something is posted and it's posted anonymously. It might be libelous, you know, Debbie44 posts libelous content. Well, the First Amendment does not require people to identify themselves, not just on the internet, in anything. I mean, freedom of speech does not require self-identification. A person can walk up and down in front of the union and say, price is too high, or whatever. And they don't have to say, I'm Fred Smith, and this is my opinion. They don't have to do that. You can do it anonymously. But the dendrite says that if there's a clear showing that content is libelous, posted by Debbie44 or whatever, that the court may order the platform or the internet service provider to provide whatever information it has about that person. In other words, when you join got a Gmail account or whatever, you put in your correct information, but you're going to post as Debbie44. Well, under certain circumstances, a court could order Debbie44's identity to be provided if the internet service provider or whatever it was, whatever platform it was, had that information. And so another question is, what about if there are errors? And media sites have kind of worked through this now and are gotten to the point where they will fix a mistake in an online story and then note that the story has been updated since it was first posted. Before we go on to the next element, we need to think about this. Again, publishing any information can be, and often does, injure reputation. If I tell you that the prices are too high at Panda Express, you might think twice about whether you were going to shop at Panda Express. But number one thing was, yes, I injured the reputation, but number one, it was my opinion, which we'll talk about later. And number two is it wasn't provably false. So publishing information that injures a reputation is not of itself libel. Okay, you can hurt some reputations are hurt a lot, and it can be truthful information, and it can be opinion information. The reputation is harmed, but it's not libelous. Okay. In the next segment, we'll talk about the next element, false statement of fact.